Hello everyone, welcome you all to the course on corporate laws and governance. In today's video, we are going to look at board of directors. First, let's look at the meaning of board of directors. According to section 2, subsection 10 of the Companies Act, board of directors means the collective body of the directors of the company. According to section 2, subsection 34 of the Companies Act 2013, director means a director appointed to the board of the company. And according to section 149 subsection 1 of the Companies Act 2013, every company should have a board of directors consisting of individuals as directors. What it means is only the real individuals can be the director of the company, and any corporate body or a company cannot act as the director, because a company is an artificial person and they are not the natural person. So, no company is allowed to act as the directors, and there should be a minimum of 2 directors for a private company. It is 3 directors for the public company. Again, the minimum number of directors for a Nidhi company is 3. If it is going to be an 1-person company, then there should be a minimum of 1 director. With respect to the maximum number of directors, it is 15 for any type of company, including the 1-person company. In case a company wants to have more than 15 directors, then they can increase the number by passing a special resolution in the general meeting. And directors are needed for a company for the reason that the company is an artificial legal entity, and the company cannot operate on its own. The company needs a natural person who will act on behalf of the company. For that, the directors are needed. Even one of the members of the company can become the director of the company. Now, let us see what are all the different types of directors we have. First one is the women director. A listed company should definitely have a women director, and if a public company has a paid up capital of rupees 100 crores or more, or if it has a sales turnover of 300 crores or more, then it is mandatory for the public company to have at least 1 woman director. There is another type that is called the resident director. Resident director is expected to be in the company for a period of not less than 182 days during a financial year. Their presence is needed in the company, or they have to be in the country in which the company operates at least for a period of 182 days in a financial year. Then we have one more category called the independent directors. Independent directors, there should be a minimum of 2 independent directors for a public company if the public company's paid up capital is going to be 10 crores or more, or if its sales turnover is going to be 100 crores or more, or if its outstanding deposits, debentures, loans, etc. is going to be 50 crores or more, then it is mandatory for the public company to have a minimum of 2 independent directors. Who is an independent director? Independent director is that person who would be acting for the best interest of the company, in the sense they will have a neutral view about all the major decisions of the company, and they are not supposed to get swayed by the discretion of the other directors of the company. Then we talk about one more category, which is the interested director. Interested director means they are those directors who have special interest in some of the contracts of the company. Maybe that they are part of the other party of the contract, or some of the family members would be part of the contract in which the company is planning to enter into. In such cases, the interested director should divulge that they have interest in those contracts to the company, so that they should not be present when decisions are made with respect to the contract. Another type that we have is the executive director and the non-executive directors. Executive directors are those directors who would be very active in the company, in the sense they would be involved in the day-to-day activities of the company. And if we see the managing director and the whole-time directors fall under this executive directors. Non-executive directors will not be that active, in the sense they will not be involved in the day-to-day activities of the company, and these non-executive directors would be present whenever major policy decisions are made. Independent director, nominee directors fall under this non-executive directors category. Now, let us look at the position of directors in the company. First is, directors are considered as agents of the company, for the reason that the company is an artificial legal entity, and the company cannot operate on its own, and the company requires the natural person to act on their behalf. Directors act as the agents for the company. And if we look at the case of Ferguson versus Wilson, here in this particular case, the directors of the company were given the right to allot the shares to the shareholders, and the directors of the company allotted the shares to most of the shareholders in the company, as well as they allotted the shares to themselves. When the shares that was allotted to Ferguson was not very substantial, and it did not it was not very profitable or favorable to Ferguson. So Ferguson went to the court stating that one of the directors, Wilson, should pay damages to Ferguson for not allotting the shares according to his discretion, and he also asked the court to order Wilson to transfer his shares to Ferguson. But the court held that Wilson was the director, and Wilson was actually performing the job as the agent of the company, and the Wilson cannot be made liable to pay damages to Ferguson. So here it clearly says that the directors are the agents of the company, and they are not the agents of the members of the company. In the case of Indian Overseas Bank versus RM Marketing, we could understand that the director of the company cannot be made liable for the loans that the company takes unless and until the director has given personal guarantee, because whatever loan that the company takes, only the company is liable, not the director, for the reason that director is only the agent who's acting on behalf of the company. So unless and until the director has given any kind of personal guarantee, the director cannot be made liable for the actions of the company, as they play the role of agents. Directors also act as trustees. trustees means because directors are involved in the day-to-day activities of the company and they are responsible for the finances of the company. So, it is the duty of the director to ensure that there is no mismanagement of the finances of the company. They hold a fiduciary relationship with the company. Though we say that the directors hold a fiduciary relationship with the company, it doesn't mean they hold a fiduciary relationship with the members of the company. That we can understand through the case between Percival versus Wright. In this particular case, Wright, one of the directors of the company, bought the shares of the company from some of the shareholders at a price higher than the prices that was quoted by the shareholders. When Percival went to court stating that Wright has bought the shares of the company from the existing shareholders at a higher price, it was held that Wright cannot be penalized for it because Wright is the trustee only to the company, not to every members or every shareholders of the company. But the case between Ramaswamy Iyer and Brahmaya and co. Proved that if the director is going to involve themselves in any kind of fraudulent activities or mismanagement of the funds, then in that case the directors are liable to the company as well as to the shareholders because it affects the credibility. Directors are considered to be the organs of the company. Though they are considered to be the organs of the company, the case between Bath versus Standard Land Company proved that no outsiders can make the directors liable for the actions of the company. The reason being, whatever directors do on behalf of the company, only the company can be made liable, not the directors, as they are only the agents. Next, let us look at the appointment of the directors. Section 152 of the Companies Act 2013 deals with the appointment of the directors. First, let us look at the appointment of first directors. First directors, the name of the first directors would be given in the article of association when the company goes for its incorporation. In case the company does not mention any of the first directors in its article of association during its incorporation, then whomsoever has subscribed to the memorandum of association, they would be considered as the first directors. But whenever we talk about subscription of the members to the memorandum of association, even individuals as well as corporate bodies can subscribe to the memorandum of association. So, only those individuals who have subscribed to the memorandum of association would be considered as the first directors in case the company hasn't mentioned the name of the first directors in the article of association. Let's if there is going to be corporate bodies that have subscribed to the memorandum of association, they are not eligible to be called as the directors, because we all know that only the individuals, the real person can be the directors, not an artificial legal person can be made as the director. When the first directors are not announced in the article of association, then it is the duty of the company to appoint the first directors after the incorporation of the company. Once these first directors are appointed, their tenure would be it would be valid until the first annual general meeting of the company. Until then, they will be acting as the first director. Post that, after the first annual general meeting, the company should go for the appointment of the subsequent directors in the succeeding annual general meetings of the company. there are some requirements that should be kept in mind at the time of the appointment of either the first directors or the subsequent directors. First thing is, if at all any individual is to be appointed as the director, that the director should have the director identification number. This identification number should be got from the Ministry of Corporate Affairs. It should be got before the director is being appointed. So, every person who wants to be the director, who wants to get appointed as the director, should definitely have the director identification number. And whomsoever wants to get appointed as the director, they should give a declaration. They should declare that they are not disqualified to be the director, and the person who wants to get appointed as the director should also give a written consent that they are willing to be appointed as the director. Yes, and DIR 2 form should be filed by the director who wants to get appointed with the company to the company, post which the company should file a DIR 12 with the registrar of companies, stating that the so and so individual is willing to act as the director. Whenever the board of directors appoint the independent director, they will have to give an explanatory statement about why they choose so and so as the independent director, and why do they feel that so and so individual would be apt to act as the independent director. This explanation should be given by the board of directors at the time of the appointment of the independent directors in the general meeting. So, these are all some of the aspects that should be done whenever the directors are appointed in a company. And now let us look at the appointment of rotational directors. Rotational director, this concept has come into the picture mainly to protect the interest of the company. Somewhere down the line, if a particular director is going to be there forever, there are chances that they may be acting for their own interest. So, in order to protect the interest of the company, especially the public company, it is mandatory that some of the directors should be appointed on rotational basis. When the directors are appointed on rotational basis, we call them as a rotational director. Whenever they are appointed on rotational basis, that means they would be retiring by rotation also. As per the Companies Act 2013, every public company should have rotational directors. Two-thirds of the total directors should be appointed as rotational directors, and they would be retiring by rotation. And who will be going for the retirement? This would be decided by the number of years that the rotational director had been serving the company. Whomsoever has served the company as the rotational director for a longer period, they would be made to retire by rotation. In case there are two directors who have the same years of association with the company, they have to mutually agree upon that who will get retired by rotation. In case they do not come to any kind of mutual agreement, then the decision would be made by lottery method. One thing to be noted, that 1/3 of the 2/3 of the rotational directors have the right to get reappointed with the company, and the 1/3 of the directors can be appointed as the non-rotational directors, who would be considered as the permanent directors. But these rules of rotational director come into picture only for the public company. If a private company is a subsidiary of the public company, this rule is applicable to them too. Next, let us look at the qualification of directors. If an individual wants to get appointed as the director, then it is mandatory that they should have the share qualification. What is this share qualification? Share qualification means they should hold the shares of the company. How much should they hold? If we look at it, the value of the qualification shares should not be more than 5,000 rupees. It can exceed 5,000 rupees when the nominal value of the share is going to be more than 5,000 rupees. Otherwise, the share value that the directors are going to have, it should be 5,000 rupees or lesser than that. It cannot go beyond that. In case a director does not have the shares with them, then they will be asked to, either they will be asked to vacate the office, or they will be asked to pay fine for not having the share qualification. And this particular share cannot be in the form of share warrant. The directors should hold it in the form of share capital, and they cannot hold these shares in the form of share warrant. Next, let us look at what and all disqualifies an individual to act as director. First one is unsound mind. If the court has declared that an individual is of unsound mind, then that person is not eligible to act as director. Again, if a person is declared as insolvent by the court, again that person is not eligible to act as the director. If an individual has served the imprisonment for a minimum period of 6 months or more, then they are not eligible to act as director if the after the release from the imprisonment, at least for a 5 years period, they are not supposed to act as directors. After the expiry of 5 years from the date of release from the prison, then only they are eligible to act as director, not before that. And if a director has not, if an individual has not paid for call of his shares for 6 months period, again that individual is not eligible to continue as the directors of a company. An individual would be, or a director would be asked to vacate the office for any of the above reasons, like when the person is going to be of unsound mind or insolvent, or has served jail his time period of a minimum of 6 months or more in the jail, and if that and after the release they cannot be the director for a period of 5 years. In all these cases, the individual would be made to vacate the office. The individual will also get disqualified if he or she is going to absent himself or herself from all the meetings of the board of directors without applying for the leave of absence. In case there is a contract and the individual fails to disclose his or her interest, if at all they are part of that particular contract, then again they would be asked to vacate the office. Next, let us look at the removal of directors. The directors may be removed by the central government. When will the central government go for the removal of the director? For that, the members of the company should apply to the central government that they do not want so and so to act as the directors. And who can apply? Only those members who have not less than 1/10 of the paid up share capital, and in case the company is not having the share capital, then the members should have not less than 1/10 of the voting rights. Only these people can make an application to the central government for the removal of the director. And here what happens, the central government would be hearing from the director who the members want to get removed. The directors have the right to be heard, and the directors can give their explanation about this particular problem, and if the central government is convinced that the director is not eligible to continue in the post, then the director would be removed. But before removal, the directors would be given the opportunity to explain their position. Next, the removal can be done by the company law board also. So here again, the National Company Law Tribunal goes for the removal of the directors when the members of the company file a petition that they do not want so and so to continue as the director. Sometimes even the central government may file an application with the National Company Law Tribunal for the removal of directors whenever they feel that the directors are into mismanagement of funds, or they are affecting the interest of the minority shareholders or any particular group of shareholders. Whenever they feel like in order to protect the interest of the stakeholders, the directors is to be removed, then the application would be made. Again, here the directors would be given the opportunity to be heard, in the sense they would be given an opportunity to explain their position. Only when the National Company Law Tribunal is convinced that those directors are actually they are a threat to the interest of the company or interest of the majority of the stakeholders or a minority shareholders, they will go for the removal of the director. The third is the removal would be done can be done by the shareholders also. If the shareholders want the directors to get removed, first of all what they will have to do is they will have to send a special notice to the director whom they want to get removed from the board. Once the special notice is given, then the general meeting would be conducted in order to pass the ordinary resolution in the general meeting to effect the removal of the director. Before passing the ordinary resolution, the director would be given an opportunity to be heard, in the sense the director can explain his or her position to the shareholders. If the ordinary resolution is through, then the director would be removed and the same would be intimated to the registrar of companies. The director of the company can also be removed when they voluntarily resign. If the director does not want to continue in the position of the director, he or she can very well resign, and they have to put the resignation letter to the board, and the board will go through that, and the board should give consent for the resignation, and the same resignation details have to be submitted to the registrar of companies too. Once the board approves the resignation, then from the date of approval, the director ceases to exist in the position of the director with the company. Next, let us look at the powers of the directors. Directors are the agents of the company. They operate on behalf of the company. So, their major power is they will be managing the company's affair. They are responsible for the day-to-day activities of the company. They are responsible for making the policy decisions. So, they are there in all the strategic, tactical and the operational decisions of the company. So, the first power lies with the director is to manage the affairs of the company. The directors can definitely delegate their powers to the manager or the managing director or the chief executive officer, depending on the kind of duty that they want to delegate. But there are certain areas where delegation of power is not allowed. The director cannot delegate the power to make calls on the shareholders in respect of the money unpaid on their shares. They cannot delegate the power to borrow money on behalf of the company to anyone, and they cannot delegate the power to make political contributions to any of the the members or those who hold different key managerial positions, these powers cannot be delegated. And again, the directors have the powers to borrow. They have the powers to borrow. Only their borrowing power is to the extent of the paid up share capital and the reserves of the company. In case the company wants to borrow beyond this paid up share capital and reserves, then they will have to pass a special resolution in the general meeting. Then only they can go for borrowing beyond the limits. And directors have the power to approve the financial statements like the balance sheet, profit and loss account, as well as the reports of the board of directors, which will be published in the annual report of the company. And the directors have the powers to appoint the key managerial personnel like the chief executive officer or the corporate secretary, auditors. All these key managerial positions can be appointed by the directors. And the directors have the power to call general meetings. When we say general meetings, they have the power to call extraordinary general meeting. They have the power to call the annual general meeting. So all these meetings can be convened by the directors. And they also have the power to declare dividends for the shareholders in the annual general meetings. They have the power to make a political contribution, which they can never ever delegate to anyone, but there is a limit. The political contributions that whatever the company makes, it should not exceed 7.5% of the net profits of the company in the 3 preceding financial year. So it cannot exceed 7.5%. And of course, as I have already told, the directors have the right to appoint the auditors as well as to remove them. They have every power to enter into contracts as specified by the article of association and the memorandum of association. Next, let's look at some of the restrictions that the directors have with respect to the powers. Normally, if the memorandum of association or the article of association feels that the board is not competent enough to take some decisions, then in that case, the decision would be taken by the shareholders in the general meeting. Similarly, if the memorandum of association and the article of association clearly specifies that the decisions should be taken, certain decisions to be taken only in the general meetings, then again directors cannot take those decisions and the decisions should be taken in the general meeting. Let's look at some of the scenarios where shareholders take decisions in the place of director. And this happens in certain scenarios, like if the transaction is going to be malified. What is malified? If the directors are going to involve into the transactions with bad intentions or which are against the interest of the company, in that case the shareholders can interfere and they can take the decisions for the company and instead of the directors. In the case of Marshall's Valve Gear Company Limited and Manning Waddell and Company Limited, we can see that Manning and Waddell where the directors of Marshall's Valve Gear Company Limited also. Marshall was he was one of the directors of the company and he was also having the majority of the shareholding. And Marshall felt that there is infringement of the intellectual property rights of Marshall's Valve Gear Company Limited by Manning Waddell and Company Limited. So he wanted to take legal action against Manning Waddell and Company Limited. But the co-directors Manning and Waddell, who were part of the defendant company, they stopped that Marshall should not go with the legal with the legal case, but Marshall went ahead and sued Manning Waddell and Company Limited in the capacity of the shareholder, because he felt that these directors were acting with bad intention. If the board is considered to be incompetent, then the shareholders will take decisions on behalf of the board. In the case of Vishwanathan versus Tiffins, what happened? The board of directors were appointed by the shareholders because at that time the existing directors were not having the competency to appoint the directors. The court held that it is very much valid that the whatever appointment that the shareholders made was valid, as the board was incompetent to appoint the directors at that particular time. And if there is going to be a deadlock among the directors, then the shareholders can definitely interfere and take decisions. In the case of Baron versus Porter, this particular company was run by Baron and Porter, and both were the directors as well as the shareholders, and they couldn't come to an agreement on a particular decision. So there was a deadlock, and whatever Baron was telling, Porter did not agree to, and vice versa. Then what happened? Baron went to the told Porter that in the capacity of the shareholder, he will appoint more directors in the company in order to break the deadlock. So these are all the scenarios where the director's power will not be taken into consideration, and the shareholders can interfere and can take decisions for the company. Next, let's look at the duties and the liabilities of the directors. Director, they operate on behalf of the company, so they have to take into consideration the interest of the company, and whatever decisions they make, it should be protecting the interest of the company. They should always put the interest of the company ahead of their personal benefits. If there is going to be any kind of breach of trust by the director, then the director is very much liable for their acts. For instance, if the director does not disclose the profit which he or she makes to the company, then they are liable for the breach of trust, and they will have to disclose the profit that they make, and they will have to return the profit whatever they have made during the course of business. If they are going to trade in such a way that it is beneficial to them, because they have the corporate control, and if it's going to affect the interest of the company, again they are liable for their action. If we look at the case of Regal Hastings Limited versus Gulliver, Regal Hastings Limited was having cinemas, and they went ahead acquiring more cinema theatres, and which acted as its subsidiary. And the directors of the Regal Hastings Limited, what they did was like they sold the shares of the holding companies as well as the subsidiary companies at a very profitable rate to the outsiders. So actually they did this against the interest of the company, and they were making a huge profit for their own benefits. So the court held that whatever transaction that the directors of the company got into is not correct, and they are liable for their action. And if the directors are going to misuse the corporate information, in the sense if they are going to share the undeclared or unpublished information like the profit of the company or the different projects that the company has, if they are going to give all these information to the outsiders, then they are liable for their action. And these directors are expected to operate in due diligence. They have to always apply their due diligence, and they will have to operate for the best interest of the company. In case they are going to cause loss to the company because of their negligence, then they are liable for their negligence. In case the company is going to come with any kind of false information due to their negligence in the annual report or in the prospectus of the company, because of which the shareholders or the depositors get affected, then the directors are liable liable for the loss that they have caused to the shareholders or to the depositors or the debenture holders because of the false information that they have given. The directors have the duty to attend the board meetings, and they are liable for any of the non-attendance. In case even the directors would be asked to vacate the office in case they do not attend the board meetings. For instance, if a director is going to miss 3 consecutive meetings, or if the director is going to miss all the meetings that was conducted in a 3 months period, whichever is higher, then the director would be asked to vacate the and if they have done it without applying for the leave of absence, then the director is liable or is liable for their action, and they will be asked to vacate the office. And there are certain duties which they cannot delegate, which we have already seen, like they cannot delegate the power to borrow money, they cannot delegate the power to make political contributions. There are certain duties which they can never ever delegate to any of the key managerial personnel, and they are also liable for the actions of the co-directors. If the co-directors are involved in any kind of fraudulent activities, the other directors are also equally liable for these activities, but later on they can claim their share from the co-directors. And wherever, in whichever transaction that the director has interest, it is mandatory for the director to disclose the interest, because if they are not going to disclose, it would result in conflict of interest. So, that can never ever be done. This we can understand in the case between Aberdeen Railway Limited with Blaikie. Aberdeen Railway Company entered into a contract with Blaikie, but what happened was one of the directors of Aberdeen Railway Company was also the managing partner in Blaikie. So, whatever transaction the Aberdeen Railway Limited Company had gone with Blaikie, they wanted to stop it for the reason that one of the director was part of both the companies, and the judgment was in favor of the company because there is a conflict of interest, because one of the director, because the director did not disclose the interest, stating that they were also part of the other company in which the company had entered into contract with. So, wherever or whichever transaction that the director has interest, it is the duty of the director to disclose it to the company. Next let us look at the remuneration of the directors. Section 309 of the Companies Act 2013 deals with the remuneration of the directors, and normally this remuneration of the directors would be stated in the article of association of the company, or this remuneration for the directors would be decided by passing a resolution in the general meeting, and the resolution can be an ordinary resolution or the special resolution as specified in the article. Ordinary resolution means it should be, the voting should be favorable for the remuneration. It should be more than 50% of the shareholders should say like they are in favor of it. If it is special resolution, 75% or more of the vote should be favoring the remuneration that is to be paid to the directors. And if we see here, there is a limit on the maximum remuneration that can be paid to the director. Section 198 of the Companies Act deals with this total maximum remuneration that can be given to the directors, and as per the Companies Act, it should not exceed 11% of the net profits of the company in a financial year. And in case the company makes loss or it does not make any profit at all, they may go for a minimum remuneration for the directors. And there is also a limit for individual directors. For if a company is going to have one managing director or a whole-time director, then their remuneration should not exceed 5% of the net profits of the company. If they are going to have more than one managing director and whole-time director, the remuneration put together should not exceed 10% of the net profits of the company. Next, let us look at, there are certain rules which are specified by the Company's Appointment and Qualification of Directors Rule 2014. it says that the company can go for conducting board meetings through video conferencing. It is allowed, not that all the board meetings should be conducted only through the physical mode. It can also be conducted through video conferencing or any other online mode. And whenever they go for this video conferencing, they should ensure that there is a very good audibility and there is no interruption while conducting the board meeting, and that all these online board meetings should be recorded. It should be kept safe. All the files should be, audio files and video files should be kept safe. And notice should be given to all the directors that the board, about the board meeting, about the details of the board meetings. In case one of the directors do not respond to the notice, then it is implied that he or she is willing to attend the board meeting. And as we have already seen, there should be a women director on board for any listed company or any public company which is having a paid up share capital of 100 crores, or if its a sales turnover is going to be more than 300 crores or more, then there should be a women director in that company. And there should be a minimum of 2 independent directors in a company, provided the company has, if it is a public company, and if its paid up share capital is going to be 10 crore or more, or if its sales turnover is going to be 100 crore or more, or if its outstanding debentures or deposits is going to be 50 crores or more, then it is mandatory that the company should have the independent directors, minimum of 2 independent directors. Whenever the director is appointed, the director should give the written consent, and this written consent would be given by DIR 2 form by the director to the company, and the company would be submitting DIR 12 form to the registrar of companies. And the director's details, it is mandatory for the company to submit the details of the entire details of the directors to the registrar of companies. And whenever the director resigns, a copy of the resignation letter is to be submitted to the registrar of companies. Thanks for listening.